The Jeffrey Epstein case, a sprawling scandal of trafficking and elite connections, has become a lightning rod for public distrust in the American justice system's capacity to hold powerful figures accountable. Epstein, a financier linked to global luminaries, orchestrated a network abusing minors across his properties in Manhattan, Palm Beach, and Little St. James from the 1990s to 2018. His arrest in 2019 by the Southern District of New York, followed by a death officially ruled as suicide, and the Department of Justice's closure of the investigation in July 2025 under Attorney General Pam Bondi, FBI Director Kash Patel, and Deputy FBI Director Dan Bongino have provoked widespread outrage. Despite voluminous evidence, including flight logs, a contact book listing 1,500 names, over 250 victim testimonies, and seized digital media, the DOJ concluded that no new charges were viable, citing insufficient evidence to pursue third parties. This decision, set against a backdrop of perceived systemic bias favoring influential figures like Bill Clinton, Prince Andrew, and Donald Trump, has intensified public demands for accountability. The 2008 non-prosecution agreement granting immunity to co-conspirators, irregularities surrounding Epstein's death, and Bondi's unfulfilled claims of a client list and extensive video evidence fuel suspicions of a cover-up. The DOJ's inaction, despite its vast investigative resources, prompts questions about legal constraints, political motives, and potential concealment. Since 2018, media coverage has amplified the case's prominence, highlighting Epstein's trafficking network and its elite connections. Yet the closure leaves victims and society questioning whether justice was deliberately withheld. This article examines the evidence, Epstein's death, the DOJ's closure, and public expectations, analyzing the multifaceted reasons: legal barriers, political expediency, elite evasion, and speculative cover-ups behind the case's termination, revealing a justice system strained by the challenges of prosecuting the powerful and the weight of public demands for equality under the law. Part 1. Evidence and legal barriers to prosecution. The Epstein case's closure in July 2025 hinges on substantial evidence that failed to yield new prosecutions, constrained by stringent legal barriers. The FBI possesses flight logs documenting over 100 passengers on Epstein's private plane, including Bill Clinton, Prince Andrew, and Donald Trump, alongside victims like Virginia Giuffre, who traveled to trafficking hubs like Little St. James. A single contact book with 1,500 names, seized during the 2005 Palm Beach investigation and referenced in the 2019 Manhattan raid, lists social and business associates, some annotated with terms suggesting illicit roles. Over 250 victim testimonies detail abuse by Epstein and associates like Prince Andrew, yet these led to civil settlements rather than criminal charges, as seen in Andrew's 2022 $16 million settlement with Giuffre. Digital evidence from 2019 raids, including CDs, hard drives, and surveillance footage, was reviewed, but the DOJ's 2025 memo concluded no incriminating material was found, a claim the public questions given Epstein's known surveillance systems. Financial records showing victim payments and offshore accounts hint at money laundering. Yet no elite was implicated, fueling speculation of evidence suppression. The 2008 non-prosecution agreement, negotiated under Alexander Acosta, granted immunity to co-conspirators like Sarah Kellen, blocking federal charges unless new, post-2008 evidence emerges. State-level abuse charges face statutes of limitations of 5 to 7 years, unlike federal trafficking laws, but corroboration remains elusive. Court-ordered seals protecting over 1,000 victims' identities restrict access to evidence like surveillance footage, limiting its use in open court. The DOJ's review of 300 gigabytes by 1,000 agents found leads exhausted, citing encrypted or damaged data. Speculation suggests the DOJ avoided prosecutions to protect elites who could leverage legal defenses or flee to non-extradition countries. The failure to pursue financial tracking via FinCEN or pressure witnesses like Kellen indicates a lack of resolve, leaving victims without justice and fueling beliefs in systemic bias toward the powerful. Part 2. Epstein's death and systemic anomalies. Epstein's death on August 10, 2019, officially ruled a suicide, remains a focal point of public skepticism due to irregularities suggesting incompetence or deliberate orchestration. Found hanged with a bedsheet in his Metropolitan Correctional Center cell, Epstein's death followed a July 2019 incident, possibly a suicide attempt or assault, and his premature removal from suicide watch against psychological advice. Malfunctioning cameras, the camera angle recording his incarceration, including a missing minute in 2025 released footage, and falsified guard logs by sleeping guards Tova Noel and Michael Thomas, raised doubts, though the 2019 autopsy and 2023 Inspector General report confirmed suicide. Epstein's $500 million fortune, connections to prominent figures like Bill Clinton, William Barr, and William Burns, alleged intelligence ties through Ghislaine Maxwell's father, and links to agencies like the CIA or Mossad and other intelligence figures underscore his extensive influence, raising questions about whether he was arrested without forewarning or under specific contingencies. The Southern District of New York sealed indictment prevented flight, but his failure to evade capture, despite a lenient 2008 plea, puzzles observers. Theories propose murder to silence him, a faked death for relocation to a non-extradition country, or protective custody to shield his network, driven by his potential to expose powerful figures. The DOJ's closure without addressing these anomalies intensifies suspicions. Reasons for inaction include legal constraints, as sealed evidence limited prosecution options, and political pressures, as Trump sought to focus on other priorities in July 2025. Speculation suggests the DOJ withheld incriminating footage to protect elites or leverage it for political blackmail, though the unsigned 2025 memo claims to have found no such evidence. The public questions how a connected financier was arrested without a tip-off, suspecting an orchestrated effort to silence him or exit him from public. The DOJ's failure to pursue international leads, such as boat logs from Little St. James, reinforces beliefs that systemic failures or deliberate concealment protected Epstein's associates, denying accountability for heinous crimes and leaving victims without closure. Part 3. Political pressures and DOJ's strategic choices. The DOJ's closure of the Epstein case in July 2025, under Pam Bondi, Kash Patel, and Dan Bongino, reflects a confluence of political pressures, legal constraints, and strategic decisions. The DOJ reviewed 300 gigabytes of evidence, concluding no basis for new charges, despite Bondi's earlier claims of a client list and extensive video evidence, later contradicted by Patel and case lawyers. The 2008 non-prosecution agreement, court seals protecting victim identities, and state statutes of limitations limited prosecution options. Bondi's February 2025 release of mostly public records, including flight logs naming Trump, disappointed supporters expecting elite accountability. Trump's reported frustration in July 2025, prioritizing issues like national emergencies, suggests a desire to end a divisive investigation that risked political fallout. The contrast with aggressive prosecutions, such as Daniel Mackey's 2018 conviction for satirical memes or over 1,200 January 6 defendants charged for lesser offenses, underscores perceived bias toward elites and selective prosecution. Speculative motives for closure include protecting powerful figures, as elites could delay cases with legal teams or flee to non-extradition countries. Theories also suggest Trump, linked to Epstein through plane flights and social circles, sought to avoid exposure, though no victim accuses him. Alternatively, the DOJ may have aimed to leverage evidence for political gain, though no proof currently publicly supports this. The public skepticism about the absence of incriminating footage, given Epstein's surveillance, fuels cover-up theories. The DOJ's decision to prioritize resources over an expansive but potentially low-yield investigation, rather than pursue financial or witness leads, suggests questionable pragmatic inaction. This failure to provide transparency or pursue accountability deepened public distrust, leaving victims and society convinced that the justice system prioritizes elite protection over justice for heinous crimes. Part 4. Elite evasion and public demand for accountability. The Epstein case epitomizes public frustration with a justice system perceived to shield elites while punishing ordinary citizens. Federal trafficking laws, with no statute of limitations, should enable prosecutions, yet figures like Sarah Kellen, protected by the 2008 agreement, and Prince Andrew, who settled allegations civilly, remain uncharged. The DOJ's 2025 closure, despite evidence of Epstein's network, fuels beliefs that elites evade justice through wealth, legal maneuvering, or flight to non-extradition countries. The public questions the DOJ's claim that no incriminating videos or photographs were found, suspecting suppression to protect powerful figures. Reasons for closure include legal barriers, as the 2008 agreement and court seals restricted evidence use, and political motives, as Trump prioritized other issues over a divisive case. Speculation suggests the DOJ avoided prosecutions to shield elites, leverage evidence for blackmail, or conserve resources for higher priority initiatives. Public demands for accountability, amplified by media since 2018, reflect a call for equality. The DOJ's failure to pursue leads, such as international records or witness testimony, despite FBI capabilities, indicates a lack of resolve. Alternative approaches, such as releasing a redacted list of names or explaining evidence limitations, could have addressed public demands without violating victim privacy. Theories propose that Epstein's death was orchestrated to silence him, protecting his network, or that the DOJ closed the case to avoid exposing Trump's ties or to exploit evidence for undisclosed purposes. The closure benefits elites named in records, leaving victims betrayed and reinforcing perceptions of a system that favors the powerful over accountability for crimes against minors. Conclusion. The Jeffrey Epstein case exposes a justice system grappling with legal, political, and ethical challenges, failing to deliver accountability for a trafficking network involving powerful figures. The DOJ's July 2025 closure, citing insufficient evidence after reviewing 300 gigabytes, reflects a confluence of barriers. The 2008 non-prosecution agreement, court seals, and state statutes of limitations. Flight logs, a contact book, victim testimonies, and seized digital media confirm Epstein's crimes but lack corroboration for new charges, leaving figures like Prince Andrew unprosecuted. Epstein's suspicious death, marked by jail irregularities, fuels theories of murder or escape, suggesting possible concealment. Public disbelief that no incriminating footage was found, despite Epstein's surveillance, underscores distrust. Reasons for closure span legal constraints, evidential gaps, elite evasion through wealth or flight, and political expediency to end a divisive case. The contrast between prosecutions of ordinary citizens for exaggerated charges, minor offenses, or victimless crimes and leniency toward elites underscores systemic bias in the justice system by those tasked with upholding the law, who neglect responsibilities or abuse power. Epilogue. The Department of Justice's decision to close the Jeffrey Epstein case in July 2025, despite the absence of statutes of limitations for federal sex trafficking, left a legacy of public distrust, as alternative approaches that could have addressed demands for transparency and accountability were not pursued due to legal, ethical, and political complexities. Releasing a redacted list of names from existing records, accompanied by a clear statement that association does not imply criminality, could have signaled openness to the public, countering perceptions of concealment while navigating potential defamation lawsuits from influential figures with robust legal resources. Pursuing limited prosecutions against facilitators, using fresh evidence to circumvent immunity agreements from 2008, might have encouraged cooperative testimonies revealing additional network members, though risks of acquittals due to insufficient corroboration and potential harm to victims deterred such actions. Issuing a detailed public statement clarifying investigative constraints, such as immunity protections, jurisdictional barriers, or inaccessible digital records, could have fostered trust by explaining why prosecutions stalled, balancing transparency with ethical obligations to protect victim privacy. Leveraging financial investigations through the Financial Crimes Enforcement Network to trace illicit payments or pursuing international leads via mutual legal assistance treaties with jurisdictions like the U.S. Virgin Islands or France might have uncovered new witnesses or financial trails, addressing public demands for deeper scrutiny. Pressing witnesses for cooperation, as seen in organized crime prosecutions, could have prompted disclosures from reluctant figures, though their immunity or silence posed challenges. Establishing an independent review panel, modeled on historical precedents like the Watergate special prosecutor, might have restored public confidence by objectively assessing evidence and recommending actions, ensuring impartiality without risking futile legal battles. These approaches were avoided, likely due to concerns over legal repercussions from powerful figures who could delay cases through sophisticated defenses or relocate to non-extradition countries, as well as fears of political backlash from supporters anticipating elite accountability. Speculative motives suggest the DOJ prioritized resource allocation to other national priorities, such as immigration enforcement or disaster response, over a case with low conviction prospects. Theories also propose the closure shielded influential figures from exposure or preserved evidence for potential political leverage. The case's closed status does not preclude future justice, as federal sex trafficking laws allow reopening with new evidence, such as decrypted surveillance footage, recovered financial records, newly cooperative witness testimonies, or international documents like boat logs or foreign bank transactions. A new presidential administration, taking office in 2029 or beyond, could prioritize reinvestigation, driven by public pressure or a commitment to transparency. A new DOJ director replacing Pam Bondi or FBI director succeeding Kash Patel could initiate reviews, prompted by congressional oversight, victim advocacy, or whistleblower disclosures revealing suppressed evidence. Public hearings, as used in past high-profile scandals, or victim compensation fund data could further trigger reopening, offering avenues for accountability. Without such developments, new evidence or leadership shifts, the truth about Epstein's network remains obscured, perpetuating public distrust in a justice system seen as favoring the powerful. These alternative approaches, both past and future, highlight the potential for justice through persistent scrutiny, ensuring that the pursuit of accountability for heinous crimes endures beyond the 2025 closure.